Hey everyone, Harry here to talk about Judge McAfee's severance decision in Fulton County this morning. So, recall last week he had a hearing, and that was because Ken Chesebro and Sidney Powell, who had already invoked their speedy trial rights, so they automatically were getting a trial starting October 23rd to pick a jury. They wanted to sever from one another, and it looked like they didn't have much reason, and he has denied that. But the question now was, what happens to the other 17? Because until there's a reason to sever them, they stay together. So they were, for now, all like glommed on to this October 23rd date, which they didn't want at all. It's way, way too soon for, to get ready, say Trump and Meadows and others. But Fani Willis was saying, well, let's try all 19 together. And recall, she wants, it's the same evidence because it's a RICO case. So 4 months is what she says, not counting jury selection, not counting defense case. It's a long case. And if you do it more than once, it gets ponderous, judicial resources, defendants get a preview, dress rehearsal, as it were, of the government's case. And she doesn't want to do it repeatedly, of course. But there's a riddle here that we talked about last week, because there's really no great reason under the accepted given rationales for when you sever to apply it just because, oh my God, it's a huge mess. Huge mess is not one of the severance factors. And he had methodically gone through the severance factors in denying Chesebro and Powell's motions to sever from one another. So we had talked about it then. What's he going to say? Because it doesn't seem as if there's anything clean. Well, there isn't anything clean, but he basically played the judicial discretion card saying, look, severance is a procedural and logistical inevitability. And, he's right. Basically, the idea of all 19 being pushed to trial, even if it's constitutional and, even if they have enough time so it doesn't violate due process, and you assume the Georgia Speedy Trial Act wouldn't violate due process, still, he's basically having the common sense view of like, come on, this is just too crazy and everyone would be up in arms, etc. So he's made, we're wondering, would he sever them? It sure seemed like it, the other 17. And what would he say under the law? And so, basically logistical and procedural inevitability is just his way of saying, yeah, there's nothing really in there, but we're not going to do it. Come on, that's too crazy. Now, it's interesting. So now we have 2 and 17. We have 2 groups. And what's going to happen? Will it really be just 2? Will it go to 3? Will it go to 4? Will it go to more? Fani Willis in the motions to the court, bowing to the inevitable, even as she said, articulated, you can try them all together. It was clear that they saw the writing on the wall. So they urged him, the judge, to require speedy trial waiver. Why was that? Because the worry is that people would sever and then, and only then, play their speedy trial card, which is automatic, remember, and all of a sudden you would have the 2 and 17 be 2 and 4 and 1 and 3, and you'd be looking at a whole proliferation of trials, just a total nightmare, except maybe for the defendant, it gets to be either bedlam or just so crazy that it never happens, that they wouldn't have minded. And so that was a big point they were making to McAfee. And that's the reason that you saw a steady parade of defendants, beginning with Trump and Meadows, coming in over the last 36 hours and waiving their speedy trial rights. It wasn't that they wanted to be so nice and to show them, oh, we don't need any speedy trial, don't you worry about it, because if that's a card to play, they'll want to play it. but it's because they understood that they weren't going to get severance if they didn't waive. So that's what they did. All right. So that keeps it then at 2 and 17. Now there was another natural group in the 17. That's the currently 5 people: Meadows, Jeff Clark, 3 Georgia electors, and will be 6. But of course, Donald Trump delays as much as he can, so he'll be waiting for the last possible day, which is September 30th, to try to remove his case. And it looked as if they would be a whole separate group. McAfee himself pointed out at the hearing, look, what's going to happen? It's just a nightmare scenario. Let's say they're denied removal, as Meadows already has been, and the others ought to be. Meadows had the strongest case. And so we start trying them here, and then it goes up on appeal. They have a right to appeal, and the 11th Circuit reverses and says, you know what? They should be in federal court. Now they're sitting here in state court. The case has already started, meaning it could be double jeopardy to be tried again. But they're supposed to be over across the street. It's kind of nightmarish. That nightmare, however, has been basically cleared up in the last few days, because the 11th Circuit, and this is a really good sign generally, has been moving very quickly to resolve Mark Meadows' appeal. It's the only one up there of his failed removal motion, and they've set a very quick briefing schedule and argument schedule, and it's clear that they anticipate making their decision by October 23rd, not holding things up. So that means that I think they contemplate that group of people who will be removed, they're not going to be gumming up the works of the 17, because that'll be decided before it's time to give a trial date for those other 17. So that means that potential mess that McAfee was worried about likely won't come to pass. At least the 11th Circuit is doing what it can to keep it from coming to pass. It also means that Meadows' attempt to have a stay, the air goes out of the tires there, because his argument would be, stop everything or I will suffer irreparable harm, because maybe I have a right to be in federal court. So 11th Circuit put a hold on things so that if you later find out I do have a right, I wouldn't suffer irreparable harm. But now, if they decide things in time, there is no irreparable harm. They'll just be he'll just, if they affirm, just take his place along with the 17. All right, I keep saying 17. 17 is pretty darn ungainly. 17 19ths, I don't think I can calculate off the top of my head, but it's pretty close to 90%, and of the same kind of mess. But in the order today, McAfee said there may be, we may need to have other partitions here, but right now, we'll take that up as it comes. So he's obviously contemplating that even that 17 has to be subdivided. And recall, this is, we're now at a point where defendants really ought to be considering, probably are, cooperating, getting the best deal they can, which means the early deal, and that should winnow their ranks as well. Okay, so you have the 2 going still October 23rd, and the DA said, let's put them all together, and there's no basis for severing them. And the judge saying, yeah, maybe, but it is a logical and practical inevitability. We're severing them. So for now, we've got 2 and 17. Expect the 17 to subdivide and some to plead out, but expect also McAfee and the district attorney to try to keep it as few as possible. Maybe they'll be looking for 3, say, and now that the speedy trial rights have been waived by most of those people, they can't just jam in another by saying, I invoke speedy trial, and that means I myself have to be tried in January. So 2 and 17 for now. This will be fewer yet, but we don't know how or why. But enough trouble for today, just making that basic decision, which is now set. So we're rolling along with a trial for 2, October 23rd, and the others remain together for the time being, but expect them not to stay that way. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.